explain the meaning, concept, origin, evolution, need, and relationship of administrative law with the modern welfare state. Administrative law is branch of public law that governs the organization, powers, functions, and control of administrative authorities. It regulates the relationship between the state and individuals and ensures that governmental powers are exercised according to law. According to Ivor Jennings, administrative law is the law relating to the administration. It determines the organization, powers, duties, and functions of administrative authorities. In simple terms, administrative law controls the actions of government officials and administrative agencies and protects citizens from arbitrary exercise of power. Legal provision. Administrative law is not contained in a single statute. Its principles are derived from various constitutional and statutory provisions, including Articles 14, 19, 21, and 32 of the Constitution of India. Articles 226 and 227 of the Constitution of India. Principles of natural justice. Delegated legislation, administrative tribunals, judicial review. These provisions ensure legality, fairness, and accountability in administrative actions. Essential features, conditions, or contents. The important features of administrative law are control of administrative authorities, regulates the exercise of administrative powers, protection of individual rights, safeguards citizens against arbitrary governmental action. Delegated legislation governs law making powers delegated to administrative bodies. Administrative adjudication regulates the functioning of tribunals and quasi judicial authorities. Judicial review ensures administrative actions conform to constitutional and legal requirements. Application of natural justice guarantees fairness and impartiality in decision making. Explanation. Concept of administrative law. The concept of administrative law emerged from the need to regulate the increasing functions of the government as governmental activities expanded beyond maintaining law and order. Specialized administrative agencies were created to perform various social, economic, and welfare functions. Administrative law lays down rules governing administrative authorities, public officials, government departments, regulatory bodies, and quasi judicial institutions. Its primary objective is to maintain a balance between administrative efficiency and individual liberty. Origin and evolution of administrative law. Administrative law developed significantly during the 19th and 20th centuries. Under the traditional police state, governmental functions were limited mainly to maintain law and order. Consequently, administrative law had a very limited role. With industrialization, economic development, and social reforms, governments assumed wider responsibilities. The emergence of the welfare state required the state to regulate education, health, housing, labor welfare, public distribution systems, environmental protection, and economic planning. As administrative agencies multiplied, a separate branch of law became necessary to regulate their powers and functions. Thus, administrative law evolved as an independent and important branch of public law. Need for administrative law. Administrative law is necessary for the following reasons: to control administrative discretion, to prevent misuse of governmental power, to ensure transparency and accountability, to protect fundamental and legal rights of citizens, to provide provide remedies against administrative wrongs, to ensure observance of natural justice, to facilitate efficient implementation of welfare policies. Without administrative law, administrative authorities could exercise vast powers arbitrarily, leading to injustice and abuse of authority. Administrative law and modern welfare state. The growth of administrative law is closely connected with the development of the welfare state. A welfare state seeks to promote social justice and improve the living conditions of citizens. To achieve these objectives, the government undertakes numerous welfare activities such as public health services, education, employment generation, social security, consumer protection, environmental regulation, and economic planning. The performance of these functions requires extensive administrative machinery. Administrative law provides the legal framework within which such machinery operates. Therefore, the expansion of welfare functions has directly contributed to the growth and importance of administrative law. Case law A.K. Kripak versus Union of India 1969. The Supreme Court held that the dividing line between administrative and quasi judicial functions has become thin, and principles of natural justice apply to administrative actions affecting rights. Maneka Gandhi versus Union of India 1978. The Supreme Court emphasized that administrative actions must be fair, just, and reasonable and must comply with the requirements of natural justice. Importance or significance. Administrative law plays a vital role in a democratic welfare state. It ensures accountability of public authorities, protects citizens from arbitrary action, promotes good governance, and strengthens the rule of law. It acts as a bridge between governmental power and individual rights. Conclusion. Administrative law is an essential branch of public law that regulates administrative authorities and protects citizens from misuse of governmental power. Its growth is closely linked to the emergence of the welfare state and the expansion of governmental functions in modern democratic societies. Administrative law serves as an indispensable instrument for ensuring legality, fairness, accountability, and efficient administration.